The next subcategory of NOTMA involving state of mind is the state of mind of the declarant proven circumstantially. In this case, a statement made by a person is not offered to prove the fact that is asserted in the statement, but only offered to prove that because the declarant made such a statement, the person had to have been, at that moment, possessed of a particular state of mind. An example of this kind of evidence exists in the 1920s California case of Adkins versus Brett, an alienation of affection case, a cause of action that no longer exists. In the case, the defendant was claimed to have been the person who alienated the plaintiff's wife's affection. The plaintiff sought to introduce evidence that his wife had said to him that she was having an affair with the defendant. If offered to prove that the wife's affection for the plaintiff was alienated, this evidence would be non-hearsay, because for relevance purposes, a woman who tells her husband that she is having an affair is thereby manifesting, by the mere fact of the statement, alienated affection. Please note that the statement of the fact of having an affair would be inadmissible hearsay to prove the identity of the defendant as the alienator. However, to prove the state of mind of the wife in making the statement, the evidence would be non-hearsay and admissible for that purpose. Here's another example, one that's a little more complicated. Assume that the defendant is charged with homicide and claims self-defense. His self-defense claim is based upon a first aggressor theory. He claims that the victim attacked him. Assume that the prosecution seeks to introduce evidence that 2 days before the victim died, he told a witness that the defendant had hit him over the head with a cue stick the week before in a pool hall. This evidence would be admissible non-hearsay to prove the state of mind of fear of the victim declarant, to rebut the defendant's claim that the victim was the first aggressor. The evidence would be logically relevant for that purpose. It would be evidence of a statement, but it would be evidence of a statement that's relevant merely because it was made and because by its making it proves the existence of the state of mind of the declarant by circumstantial reasoning. One who says that they were hit over the head by a person wielding a cue stick is likely to be fearful of that person. The victim made such a statement, therefore the victim is likely to have feared the defendant. This is a good illustration of both the relevance reasoning and the integration of the relevance analysis into the hearsay analysis definition of offered for the truth of the matter asserted. The last illustration gives us an opportunity to point out a distinction between direct assertions of a state of mind as contrasted with those assertions that only prove state of mind circumstantially. If the prosecution had evidence, the victim in the last hypothetical had said, "I am afraid of the defendant," that evidence would be hearsay if offered to prove the victim's fear. It's a direct assertion of fear offered to prove fear. If we contrast that with the statement about being struck by a cue stick, we see that the reasoning process to arrive at the conclusion that the declarant was afraid is one of circumstantial reasoning. One who says that they were struck by someone with a cue stick is likely to fear that person. The victim made such a statement, therefore the victim likely feared the defendant. The evidence, therefore, of the cue stick attack is non-hearsay when offered to prove circumstantially the declarant's victim's state of mind of fear. Contrasting that with a direct assertion of, I fear the defendant, the latter, the direct assertion, would be a hearsay statement. Another example of a declarant's state of mind, non-hearsay, is the classic hypothetical given to us by Professor Morgan of a woman who says, I am the Pope, when the statement is offered to prove that she suffers from a delusion. The evidence does so because one who claims they are the Pope is likely to be delusional. If the woman had said, I believe I'm the Pope, then the statement would be hearsay if offered to prove her belief, because the statement, I believe I'm the Pope, as contrasted with I am the Pope, is a direct assertion of the belief sought to be proven. It should be noted that in all these examples, if the evidence is hearsay, it may nonetheless fall within the hearsay exception for then existing state of mind, a matter that we will take up later. Even though this is so, it is still necessary for us to distinguish between non-hearsay state of mind assertions of the declarant by circumstantial reasoning and those that are hearsay but may nonetheless still be admissible within the exception for state of mind. A final category or subcategory of not offered for the truth of the matter asserted, to prove the state of mind of a declarant is an area Professor McCormick classified as non-hearsay on a theory of traces of the mind or knowledge of the declarant. In short, if a person makes a statement, the content of which proves that they have knowledge of some fact that they could have only gained by exposure to the reality of that fact, then the circumstantial reasoning would be one who says something revealing knowledge has that knowledge, the declarant said that thing, therefore they have that knowledge. An example is the 1940s Wisconsin case of Bridges versus State. In that case, a little girl, she reported that she had been molested. It was later discovered that the defendant lived in a house that was particularly described by the victim, in a room having belongings arranged in a particular way as was described by the victim. Since the victim was a very young girl and could not have gained the knowledge of the description of the house and the contents of the room except by having been there, her statements to her mother and the police revealing such knowledge were admissible as non-hearsay to prove the existence of that knowledge. A more recent example is also illustrative. One of Michael Jackson's youthful visitors described a unique mark on Michael Jackson's genitalia. The fact that the victim was possessed of such unique knowledge would have been admissible proof that he was, in fact, intimate with Michael Jackson. In all situations in which the traces of the mind theory operates, the fact must be proven that matches the stated knowledge of the individual, and it must be proven by evidence other than the declarant's statement. Again, this is another situation where evidence may be admissible for one purpose and inadmissible for another. In other words, the declarant's statement cannot be taken as proof of the fact that the statement asserts, but can only be matched with other proof of the existence of that fact. The cure for the admissible for one purpose and inadmissible for another is a limiting instruction and considerations of the operation of Rule 403. A final subcategory of evidence not offered for the truth of the matter asserted is, I say with tongue in cheek, not because. And that is that there is no further subcategorization that I have been able to come up with other than saying that the evidence is, by analysis, logically relevant to prove the fact for which it's offered, even though it's an out-of-court statement, and that it is relevant to prove that fact without the content of the statement having to be true. The late Professor John Kaplan came up with a great example of that. The example is in an imaginary case in which husband and wife die in a plane crash. For purposes of inheritance, it is necessary to prove which died first, the husband or the wife. One of the heirs seeks to prove that the husband survived the wife by evidence that a search and rescue person approached the decedent just after the crash, and the decedent was heard to say, "I'm alive." The evidence of the statement, "I'm alive," when offered to prove that the declarant was alive, is non-hearsay. Its relevance is not dependent upon the truth of the matter asserted, because dead people don't speak. If you understand that hypothetical, you can understand the operation of the hearsay rule, at least in this arena.